Alberta's appeal court ruled in a very important judgment that it was the federal carbon tax is a, quote, constitutional Trojan horse that under the guise of fighting carbon emissions would give the federal government potentially unlimited power over provincial regulations, unquote. The Alberta court further stated, quotes, that the federal and provincial governments are co-equals, each level of government being supreme within its sphere. The federal government is not the parent, and the provincial governments are not its children, unquote. The court further concluded that, quotes, the legal and practical effects of the federal carbon tax directly intrude on provincial powers, including their exclusive jurisdiction to develop and manage their natural resources, unquote. The Alberta Court of Appeal underscored the broader implications of the federal effort to anchor its carbon tax in the Peace, Order and Good Government Clause in the Constitution Act, Section 91. And they did so saying that what is authorized under the Federal Carbon Tax Act indefinitely to the future and in the sole unfettered discretion of the executive is endlessly expansive. The executive's authority is also open-ended and largely subjective, unquote. So, of course, the federal government appealed that decision to the Supreme Court of Canada, which released its judgment today. We are obviously disappointed with that decision. The Supreme Court ignored the Alberta Court of Appeal's warning and discovered a new federal power that erodes provincial jurisdiction and undermines our constitutional federal system. We'll take time to study that decision in detail. I do appreciate the three thoughtful dissenting opinions, including that of Mr. Justice Russell Brown, which warns that, quote, the true danger in the majority's reasons lies in its abandonment of any meaningful constraint on federal power, unquote. We also agree with Madam Justice Suzanne Cote that, quotes, the federal carbon tax employs a discretionary scheme that knows no bounds, unquote. The best we can hope for is that the Supreme Court has invented a one-time only carbon pricing exception to the constitutional order. We'll continue to fight to defend our exclusive provincial power to regulate our resource industries that is guaranteed in Section 92A of the Constitution, which was a condition of Alberta signing on to the patriation of the Constitution back in 1982. Albertans will continue to defend jobs, our economy, and our constitutional authority. That is why we're not deterred in any of the other defenses of Alberta's interests by today's decision. We'll continue to press our case challenging Bill C-69, the federal No More Pipelines law, which is currently before the Alberta Court of Appeal. We'll also listen to and consult with Albertans and our allied provinces on our next steps on the carbon tax. We'll do everything in our power to minimize the costs on Albertans and on our trade-exposed industries that must compete globally, while at the same time we continue to ensure that we responsibly reduce emissions from Alberta. Just because the court says that the federal government can punish people for filling up their gas tanks and driving to work and heating their homes doesn't mean that the federal government should do that. So this comes back to being a political issue, a democratic issue, which will be on the ballot in the next federal election. And I fully expect that the vast majority of Albertans, at least, who oppose this punitive carbon tax will vote to repeal it. So ultimately, this will be up to Canadian voters. I can tell you what Alberta voters think about this. They gave this government the largest Democratic mandate in Alberta history to repeal the NDP carbon tax as our first act and to sue the federal government over the constitutionality of their tax. And let me just say, there were a lot of people throughout this, a lot of the so-called clever commentators who said that this was that we were just tilting at windmills and this was all just some kind of a political ploy. We won a 4-1 decisive decision at the highest court in Alberta. We now have a third of the Supreme Court of Canada validating our position. We didn't get a majority, but it's clear that the position taken not just by Alberta, but by 6 of the provinces representing 80% of Canada's population was a strong and credible position. It's a challenge that had to be made. And no, we're not going to back down on defending our jobs, our economy, and our powers under the Federation to threats like Bill C-69. Will continue to keep our election commitment to defend our powers and our economy.